Okay, we are live and we'll continue our discussion. We are moving on to what do we want to do? We want to continue get the franchise, the miscellaneous bill or the franchise law. What do we want to change next? You had us down, Jeannie, for the franchise.
Yes, I believe that's what's supposed to be next.
Okay.
Anthea is with
Anthea is
us.
with us. Anthea, good morning.
So
Thank you for all your involvement. You're always there to help us. I'll tell you. Thank you very much. Appreciate it.
And you're very welcome. And I was listening to your discussion.
You were, right? You're good. How did we do? All right.
Yeah, you did great. It was super interesting.
Yeah.
So I have sent some language on the towing abandoned vehicle issue, 2 sections to Deputy Commissioner Smith to take a look at. We had been emailing during your break. So I think probably what makes sense is to let him process that on his end, and we can do the walkthrough of the Atvs proposals for modifications to the franchise law. And then hopefully when we get through that testimony, or you get tired of the testimony and want me to stop, we can deal with the miscellaneous motor vehicle bill.
So we want to do the franchise law now? Is that what you want to do now?
I think that makes sense to give the DMV a little time.
All right. Okay. It's all yours. Go right ahead. Thank you.
Okay, great. So Jeannie has given me share access, so I'm going to put some documents up on the screen. But the first thing I'm actually going to show you is just on your committee page. There are 3 documents posted under my name. 2 of them relate to what we're going to be talking about today. I'm going to do a walkthrough of the proposed language, which is based on what Veda submitted to what I'm calling the suggestion box that you created through Act 63, Section 5. But what I also did is I have created a chart, and I'll make this a little bit bigger so you can see it. A chart that has from that report that you got from the Department of Motor Vehicles with the suggestions from the Alliance for Automotive Innovation, AAI, and from Veda, from the dealers. You got proposals from each of them, and then you also got some commentary. You got a white paper, and you got a non-specific recommendation to just sort of consider something generally. I did not include that in this chart, but this chart has, for the proposals from the manufacturers and from the proposals from the dealers, a brief summary of the proposal, a link to the statutes it would amend, some notes from me, and then you'll see this 4th column where it comes into play. What I have done for the proposals that we're going to be going through today, which are all of the proposals from Veda, and I've turned that into about 20 pages of draft language, is I have far more in the notes column, but I do not have, nor could I, even if you gave me hundreds and hundreds of hours to do this, have a comprehensive review of what the franchise laws look like in all of the states. You know, one of the things that you all work on is the creation of law, and it's an iterative process. It builds on itself. You can't look at things in vacuums. So what might be a provision in, I'm going to pick a random state, in Wyoming, might not fit in cookie cutter cleanly to another state's franchise act. But to the extent that I've been able to, as I've been working through this language and looking at some of the laws in other states, I have included references to different or similar approaches that some other states have taken. And this is simply meant as a resource for you as you are working through this language and trying to understand how everything fits together. So you will see for the 7 proposals from Veda, an expanded notes column. And then the 4th column you received from the Alliance, the manufacturers, on the day that you heard testimony last week, January 20th, you received a letter in response to the 7 proposals from Veda. And that letter said, you know, we are not responding in detail to everything, but here are some of the concerns that we've had. So to the extent that it was covered in that letter, I've included a brief summary of response from AAI column. And again, this is just meant as a resource, not fully comprehensive. I wish I could put a bajillion different disclaimers on this document, but it really is a resource more than anything else. The final thing I will mention is Veda made 7 proposals. And when you see the draft language, it's not necessarily clear which changes go with which proposal. So to help with that, I have color coded it. So if you look at the chart, you'll see Veda Proposal 1. That will be pink just for the small designation in the language that we're looking at. Again, just a resource. We certainly wouldn't be, if this language moves forward, enacting anything with my color coding. It is just meant as a resource. So that is the chart. I'm not going to go through it, but it's something that you can look at as it provides value to you at some point going forward with this. The final things I just want to mention before getting to the language is I have not reviewed the sort of cleanup, modifications, streamlining that I did with Veda's language with Veda. And this is a very, very complicated issue. If you do move forward with this language, or if another committee moves forward with this language or an iteration of it, they're going to need to hear from dealers, from manufacturers. I am learning about franchise law along with you. This is, new to me, and you have as a resource the dealers that have access to what other dealers are doing in other states, the Alliance, what manufacturers are doing, and I will be learning about franchise law right along with you as you work on this language. So I think those are all of my disclaimers up front.
Senator Perchik?
Thank you, Anthea, for all the work to put this together, and understanding the disclaimers totally makes sense. I wondered if you or another ledge council has worked with House Commerce, because I heard that they were taking this up. Are you the ledge council for them as well?
Yeah, so we don't really, we staff issues more than staffing committees. So because this is coming out of Act 63 S47 in the suggestion box, I have stuck with it. That chart that you saw, the first 3 columns of it, and in its earlier version, it didn't have the extensive notes or the color coding. I did a walkthrough of that chart as a walkthrough of the report to House Commerce. I think it was 2 weeks ago. And I am actually going to let them know after this testimony concludes that there is now an updated version of the chart and that there is proposed language from Veda floating out there. House Transportation, all 3 committees took a different approach. You heard from the dealers and the manufacturers. House Commerce heard from me, and House Transportation heard from the Department of Motor Vehicles, and that testimony was very similar to what they provided in their transmittal cover memorandum with the suggestion box proposals. So you can sort of guess that they are not taking a position, not supporting either one, but they will be involved as it affects their administrative responsibilities.
I think we certainly want to listen to the dealers' suggestions and comments. I thought so. We'll see what the committee's deciding, but I think that the dealers made a lot of good points, and so let's go from there. Okay, next, who wants questions or?
Okay, so I can start with your language.
Well, go right ahead. Yep. Anything else?
Okay.
Go ahead. Yep.
So I'm going to share my screen again. This is those 7 proposals that you got from Veda put into draft language. And then I just have my little color coding explanation at the top.
Okay.
So changes to section 4085. This is the definitions section for chapter 108, which is the Auto Dealer Franchise Act. It's got a longer name, but I'm just going to call it the Franchise Act for today's purposes. The first change you see on lines 8 to 9, this is just to conform with how we draft to sort of bring the language into a less legalese phrasing. So not a substantive change. On line 12, all throughout the Franchise Act, there's sort of a switching between calling the entity new motor vehicle dealer or dealer, just adding in dealer to make it clear that when we're talking about dealer, we're talking about new motor vehicle dealer. We're now getting to proposals from Veda related to.
You move it up on our screen so we can see 11 and 12. Or...
Oh, am I not sharing my screen? Oh.
We're seeing your screen, but it wasn't scrolling as
weird. I think it's because I switched monitors. Let's try this again.
Okay.
You'd think, a year plus into this, we would know what we were doing. Okay, are you seeing scrolling now?
Yeah.
Okay, great. Sorry about that.
All right.
Okay, so you've got my line 12, putting in dealer there. We're now getting to Veda's proposals with respect to changes to the definition of dealer. And what they are proposing is that in addition to the list, and you spent time on this last year with S47, which became Act 63, instead of having the list stop after subdivision D, and this is saying that dealers sell or lease, offer to sell or lease, solicit or advertise for the sale or lease, offer through a subscription or like agreement. We're going to be talking about that again, and that's one of the changes that was made through Act 63. Also saying that dealers can offer or sell software and hardware upgrades or changes to vehicle function and features. And this is a sort of expanded way of describing what is known as an over-the-air update. And the manufacturers in their letter would draw a parallel to like your phone or your iPad, and it needs to get a software update, and you don't need to like take it into a physical place to get that update. It's done over the air. And as vehicles have more and more about them that are computer related, then these updates will happen through that. So I do not think that this language needs to be added to the definition of dealer to do what the dealers want, which you will see in section 4097 when we get to page 11, which is to say only dealers can offer these over-the-air updates. Manufacturers cannot. So what the dealers have proposed in this language is adding to the definition of new motor vehicle dealer that they can do this, and then somewhere else prohibiting manufacturers from doing this. I think you only need to do it in one place, but if you were to be consistent with the approach that was taken with offering vehicles through a subscription or like agreement, you would add it in both places. And I think I said this about the addition of the subscription language when you were looking at this a year ago. One of the things just to remember, and we can't look at things in a vacuum, is the prohibition on manufacturers offering vehicles through a subscription. That is effective on July 1 of 2022, and that is something that the manufacturers submitted a proposal on. Still in our definition section, but now we're dealing with a definition that is related to a different proposal from Veda, and that is the definition of consumer data and the definition of a data management system. And then this relates to Veda's proposal number 4, which has to do with what manufacturers are required to do in terms of getting data from dealers and the limited exceptions when they can request data from dealers, and then how that data can be transmitted. So we'll get to more language about that. This is simply setting out the definition of data. One of the things I always do when I'm given draft language that is referencing a definition from something else is I look to see what that definition is and if it's applicable. When I first read the definition, and you'll see this on line 6 in 15 USA section 68094, I saw that it had to do with information that was collected by or in relation to financial transactions. And I wasn't necessarily sure if this was the right definition to be using to describe consumer data for purposes of dealers and manufacturers. This is the approach that Arizona took. So someone out there has vetted it with respect to Arizona, but it was something that I just wanted to flag for the committee that at some point, if there is going to be this sort of absorption of a definition from a different source, making sure that it's the right definition and it's applicable. But this would be saying what consumer data is, what consumer data isn't, and then for purposes of a data management system it's a long way of describing a system that manages and collects data and where it's located, if it's app-based in the cloud, located at the dealer's facility. So this will come into play when we get to the very dense language about consumer data and how that is protected. And then the final definition that you'll see added to the overall definition section is a definition of subscription. So as we talked about a little bit above, one of the things that will become effective on July 1 of 2022 is language that prohibits manufacturers from offering vehicles through a subscription or like agreement. This is defining what a subscription is, and it's basically saying the exchange or conveyance of an interest in a vehicle, new or used, during a period for compensation, but it does not include rental or short-term basis as defined in the purchase and use tax language in Title 32 by a rental company. And this is to take out of the spectrum of what is a subscription, the sort of traditional, I'm renting a car from like Hertz or Avis or a car rental company. So this is adding a definition to a prohibition that you added through Act 63 that will become applicable and enacted come July 1 of 2022. So those are our definitions. Now we're getting into like the meat of the proposals from the dealers. Section, what I've described as X2 for purposes of this. This is VEDA Proposal 2, having to do with warranty and pre-delivery obligations. And this is going to deal with the very, very complicated way in which dealers are paid by manufacturers for work that's done. So I have included in here language in subsection A and B that is not proposed to be amended by VEDA at all. And it has to do with what the new motor vehicle manufacturer needs to do. They need to specify in writing to each of its new motor vehicle dealers their obligations with respect to pre-delivery preparation and warranty service. It needs to compensate the new motor vehicle dealers for service that's required of the dealer by the manufacturer. This part's important. It shall provide the dealer the schedule of compensation to be paid to the dealer for parts, work, and service in connection with the work that the manufacturer requires the dealer to do. And then in subsection B, we're getting into what needs to be included in this schedule of compensation. Again, nothing in this language is proposed to be changed. I just want to point some things out in it. So the schedule of compensation that's provided from the manufacturer needs to include compensation for diagnostic work, as well as for repair, service, and labor. And then when we get to the very end of this language that you see on this page, it says, each manufacturer shall compensate each of its dealers for parts used to fulfill warranty, pre-delivery, and recall obligations of repair and servicing at amounts not less than, and this is the important part, retail amounts customarily charged by the dealer to its customers for like parts for non-warranty work. Subsection C, where you're going to see a lot of proposed changes from the dealers, has to do with what it means to be retail amounts customarily charged. One of the things, and I'm going to scroll back up to show you one more thing before we really get into subsection C. One of the things that VEDA is proposing is that for purposes of figuring out what the retail amounts customarily charged are, it will be for labor rate or parts or both. I think, and this would be something to confirm with the dealers, that it is possible that at the very bottom of page 3 in line 21, when it's talking about manufacturer compensation to its dealers, that it should have said for parts and labor used to fulfill warranty, pre-delivery, et cetera, because the retail amounts customarily charged is looking now under VEDA's proposal at both parts and labor. So then in that definition for retail amounts customarily charged, adding for labor and parts throughout, and then we are getting to what is to be considered in calculating the average percent markup for labor and parts. And it is a very, very long list that the dealers are proposing to add here. I basically took it verbatim and just did some formatting. I think questions to ask the dealers and manufacturers is what is not included in this list, since it's saying retail sales shall be considered in calculating it except for everything in this list. So what's left? What's the universe that would be calculated? And just how is this working now? One of the key changes that the dealers are proposing is that this long calculation formula that will be used, and it looks at a certain time frame and repair orders and looking within 100 of them over the course of 60 days. And it's this complicated formula, and lots of states have this, is that the dealers want it to no longer be permissive that this formula is used to figure out what the retail amounts customly charged are. They want it to be mandatory, changing this may on line 15 to a shall. And then what effect does that have on the applicability of the schedule of compensation that the manufacturer provides? Is that no longer in play? Could there be an agreement to use the schedule of compensation if the dealers don't want to go through this complicated formula? So those are some of the questions that I have about this. How would this work? How does it work currently? What would be included in the calculation of the markup if this language is enacted? And what if the formula doesn't want to be followed? So those are some initial questions that I had when looking at this language. And then the key piece that I think is potentially at the heart of the proposal is this supposed to be applying to labor and parts or just parts? I know that that is a lot. I'm gonna take this down for a second. You can see each other's faces and maybe ask me some questions.
Well, just because I was in that business, to summarize it up, I mean, and you've done a great job, Anthea, better than what you've given yourself credit for, because you've nailed it. So they just take 100 repair orders that don't have any warranty in it. This is just like people that just come in and for $42 an hour paid the rate, and this is what they did. And this is what they paid for parts. This is what they paid for service. They average it out, and that's how they get to the warranty rate. So that's how they do it now. I see they're proposing it different. They want to do it differently, but that's how they get there.
Okay, the other questions? All right, go ahead, Anthea. Go.
Okay. Again, sticking with the warranty and the reimbursement, in subdivision C3, which is all new language, this is addressing how if a manufacturer furnishes a part or component to dealer at less than or its normal customary price or for free, how that price is then marked up. And that is something that is not addressed currently in the statute. It would be all new language. Subdivision 4 on page 7, you'll see a whole bunch of text that's being struck out that has to do with how the manufacturer shall reimburse the dealer for labor performed for warranty work. I think this is being struck out to get at it should be compensated at this customarily applied rate that's being calculated in subdivision C1, but that is something that I just think would need to be confirmed with the dealers if this is to move forward, because I think that we would need to be a little bit more clear there. And it could be that I don't have the eyes of, well, this is how it works and this is what's done in the industry. So to me, it seemed a little confusing. And if that's the intent, then I think we can make that more clear. And you'll see that again. I'm going to skip 5 and 6 for a second. At the bottom of the page in subsection D, this has to do with recall work. It's saying that recall work will be compensated at the rate set forth in subsection C. And if the recall work is supposed to be compensated differently than the warranty work. And then 5 and 6, new requirements saying that a manufacturer shall not require, influence, or attempt to influence a dealer to change its prices for what it sells parts or labor at in retail customer repairs. And since the warranty work would be linked to the retail work, the two will travel together if it's based on this formula. And a manufacturer shall not implement or continue a policy, procedure, or program with any of its dealers in the state for compensation that is inconsistent with this subsection. I think some of the language that you see throughout saying you can't do anything that's inconsistent with this title, with this chapter, or any of the language that says notwithstanding the franchise agreement or any other written agreements, there is language in chapter 108 in section 4097, I think it's subdivision 19, and in section 4100 little a, not subsection A, but 4100A is the section that talks about how this applies to all written agreements, that if there is anything inconsistent in an agreement that does not comply with the chapter, it's deemed void and unenforceable, that there's this presumed language in every franchise that provides this, that anything that doesn't comply with the Franchise Act is sort of struck out of the contract. So I think this language is a belts and suspenders approach, which we love to do in statute. And this is a belts and suspenders approach where it's saying, and if it doesn't comply with the Franchise Act, then it can't be included in a contract. And we're just saying it in a couple different places in different ways. But redundancy is not necessarily a bad thing. That will take us through to the end of the calculations for the work, and the other changes that the dealers are proposing with respect to warranty and the reimbursement has to do with the audit window and the look back period, and they're proposing to decrease those. So for auditing claims and to charge back, they want to decrease that from 2 years to 1 year. And that's on page 8 at line 4 and 5. So you'll just see 2 years struck out, 1 year replaced. And then the look back for auditing of incentives and reimbursement programs, decreasing that from 18 months to 1 year and changing the triggering date for when that 1 year look back period would start. And that will take us through Veda's proposal number 2 on the warranty and pre-delivery obligations.
Questions? Good job. Okay, go ahead.
Okay, your next language, this is going to be at the start of page 9. This is Veda's first proposal, and this one has to do with the requirements with respect to the facilities and the location that the manufacturers can require of the dealers. Language that they are proposing to add in the very beginning of the section, and it would apply to all of 4096, which lists out all of the unlawful acts by manufacturers and distributors. Language that says, notwithstanding the terms of any franchise or other agreement between a manufacturer and a new motor vehicle dealer, it shall be a violation of, et cetera, et cetera. I think, again, this language might be redundant given other language in Chapter 108 with respect to saying it applies to all of the agreements and it's deemed void and unenforceable. But they are proposing it. I made the change on line 6, just taking out the as defined under this chapter, because we've already said these terms have these definitions for this chapter. Where we're getting to the changes that they are looking for with respect to dealership facilities and the location of them is in subdivision 9. And what the law currently says is that in order for a manufacturer to change the location of the dealership or to make any substantial alterations to the dealership premises or facilities in the absence of a written insurance from it. So it is problematic if they don't have this written insurance, that there will be a sufficient supply of new motor vehicles to justify the change in location or the alterations. So what the dealers are looking for with this amendment is to have that first written assurance need to be that there will be a sufficient supply of new motor vehicles that is linked to customer demand in the market, and that if there are going to be alterations, there needs to be a written assurance from the manufacturer that the new motor vehicle dealer will be able, in the ordinary course of business, as conducted by that dealer, to earn a reasonable return on the total investment in the improvements to that facility or the change in location, and a full return on the investment within 10 years. You will see that 10-year mark again in the next subdivision, because they're looking for a sort of presumptive window of compliance that would last 10 years. So if a dealership had to do repairs, they couldn't then be required to do repairs for 10 years with limited exceptions having to do with health and safety, or if there needs to be a technology improvement to sell particular cars. I am not going to do a lot of linking back to what other states are doing or my chart, but I will mention, because it has come up in conversation in this committee, that when New Hampshire made its change, which was pretty early, it was in 2013, to allow manufacturers to sell directly to consumers. At the same time, there was a change to have this sort of window of compliance be 15 years. And that is, to the best of my knowledge and the research I've done, but I would be interested to hear if this is different from the prospective manufacturers and dealers who know more holistically what's happening, that 15 years is the largest of these window of compliance periods across the country. I did see 10 years in California, also linked to a total cost of improvement threshold, but this is something that has come up in this committee before in conjunction with conversations you had about the direct-to-consumer piece. I talked about it briefly, but you've got your exceptions to when this 10-year compliance period would not prevent the requirement that there be improvements, and that's to comply with a health or safety law or to comply with a technology requirement that's necessary to sell or service a motor vehicle. I would be interested to hear what sort of technology requirements there are, especially, or anticipated to be, especially in light of electric vehicles and sort of the shifts there to that being a significant part of the market segment. And then we have, with respect to requirements from the manufacturer to make improvements to facilities, a prohibition on the manufacturer requiring that the dealer use a specific vendor or parts or services from a specific vendor to make the improvements unless some exceptions are met, and that this is not something that's going to interfere with the intellectual property or trademark rights of the manufacturer. And there is also one in subdivision 11 to say that the manufacturer cannot require the dealer to purchase essential tools and equipment to service vehicles unless the manufacturer can demonstrate that there will be a reasonable return on investment if they're required to purchase the essential tools and equipment. And again, I have no idea what that is, but I'm sure the manufacturers and dealers can tell you exactly what that is looking to.
Well, I think if you want to, what I think was, for example, there's one deal that I knew that didn't sell Corvettes, but to be able to sell Corvettes, they had to upgrade a lot of the facility with tools, inventory, parts, everything else. So there was a big demand to be able to sell a Corvette at a Chevy dealer. So I think that's one of the comparisons. Okay, Jane, you had a question? I'm sorry.
No, is this this provision? I'm just wondering. You've crosswalked and said this was modeled, or California does this, or different, New Hampshire did this. So this particular provision around tools, is that are there other states that have that same requirement?
I believe that California does. I'm going to look on my chart to see if I had included it there. New Hampshire prohibits a manufacturer from requiring a dealer to purchase goods or services from a selected vendor without allowing for the dealer to use a different vendor that is approved by the manufacturer. So I included something for New Hampshire. I did for California. California deems modifications that require goods or services to be purchased from a specific vendor when comparable goods or services are available from another vendor to be unreasonable, and they link it to a reasonable standard. So yes, I would say that California and New Hampshire are dealing with this issue, maybe not in the identical way that Veda proposed, but it is something that other states are addressing in their prohibitions on manufacturers language. And I'm sure we could find 40 other iterations of an approach to this language.
Okay. Questions? All right. Okay.
Okay, we are now moving on to in 4097 are manufacturer violations. This has to do with Veda's 6th proposal. I will not say again why I think this notwithstanding language at the top of the page is necessary. It's the same reason I've already mentioned. This is now dealing with the competition between manufacturers and their dealers. This is the section that you spent a lot of time with in Act 63, where that subscription language is. So I would say that the first part of Veda's proposal is simply a clarification. You'll remember that there was a lot of discussion in this committee last year about prohibiting manufacturers from selling parts and accessories at retail. This is saying that they cannot sell parts at retail to the end user for those new motor vehicles. I think that by saying that it is a retail sale, it would be a sale to the end user, but that could be something to get confirmation on. If that is the correct interpretation, I do not think that this is changing the prohibition in any way. And what I garnered from reading Veda's letter is that they were not intending to change this prohibition that you put into law effective July 1, 2022, a year ago. No change to the prohibition on manufacturers offering vehicles through a subscription or like agreement, but it would cover the definition of subscription would apply to this language. Where we are getting to a new prohibition on a manufacturer doing something is in subdivision little v, that's on lines 18 and 19. This is that over the air, I'm going to get my acronym wrong, over the air update. So this is saying that a manufacturer cannot offer or sell software and hardware upgrades or changes to vehicle function and features. It's something that would need to go through the dealership. I would be interested to hear about the logistics of that. When I was looking for language from other states on this, I did not find any states that had language on this. I did find articles that mentioned that this was something that had been taken up in other legislatures. I just couldn't find sort of the result of that, which makes me think nothing on this has been enacted. I also do not think Veda included a reference to another state in their proposal. So it could be something to follow up on as to whether or not other states are doing this. I can continue to look, but I hadn't found anything thus far.
Yes, Senator Bertlick, there you go. Yep.
Thea, on the parts, because we heard that that's one of the ones where we heard both sides from the manufacturers and the dealers. Did you or did they provide any information from what other states have done on that? And is it just the confusion of who's selling it? Because obviously, it seemed to me last year when we brought this up, it was just people misunderstanding what we were trying to do, but maybe we just didn't get the wording right. You know what I mean? Because it seemed that they were equating the manufacturers selling the parts through like auto parts stores or something.
I'm looking at Veda's proposal now to see if it says it. Veda further proposes to add that a manufacturer shall not engage in the retail sale of parts and accessories to the end user. To be clear that the prohibition does not prevent the manufacturer from selling parts at wholesale or to vendors that are not the end users of the parts and accessories. And testimony that I heard on this in House Commerce that I don't think this committee heard from was from GM. And I believe GM has a subsidiary entity that sells parts, and a consumer could go and buy parts directly from that GM subsidiary. So I think that that is more of the concern of the manufacturer. Again, I'm going to echo what I said earlier. My reading of Veda's explanation of its proposal, you should hear from Veda, is that adding into the end user was to add clarity, but not to change the prohibition. So I think the manufacturers would still have a similar objection that they had a year ago. At least the ones that are in the business of, in some iteration, trying to sell parts to retail end users.
So I think that might be Delco, if I remember correctly. I think they brought that up.
Right.
That's it, yeah. Okay, so in your reading of the law, they wouldn't be able to sell parts to Delco, or they don't like
that Delco wouldn't be able to sell parts to like you. I would need to look more at or hear more from GM or Delco about that business relationship and whether or not it would fall under the definition of related to the manufacturer. If the intent was to allow that sort of related entity to be able to sell parts at retail to consumers, I think you could carve it out to allow Delco to continue doing that, if that is what Delco is doing. But that might be contrary to what the dealers are looking for, which is to be the sole entity that can sell parts to someone who wants to, fix their car themselves with an OEM part.
Okay, and so they'd still be able to, the auto parts store would be able to buy them from the manufacturers, or like a body shop could buy those OEM parts. It's just like that they wouldn't sell directly online kind of thing. So So if Ford was to buy AutoZone, there may or may not be a problem.
Yeah.
Similar to Delta. Okay. Thank you.
Okay, all right. Anybody else? Go ahead. Yep, thank you.
Okay, so we now have on the top of page 12, this is just one subdivision. This is Veda's third proposal, and this has to do with an unreasonable standard. I would say that the first part of the language that you see underlined, whether as part of the franchise or a separate program, that might not be necessary given language that says the chapter applies to written agreements, but I don't know enough about how these separate programs are set up. So again, just flagging it. It could be a redundancy, but redundancies are not always bad. But it then goes on to say, it shall be considered unreasonable for a manufacturer to fail to take into account all circumstances relevant to a new motor vehicle dealer's local market when imposing standards of performance. So it's saying what needs to be looked at, and it's saying you need to look into, consider all of the circumstances that could be relevant. I will not go through the chart again, but I did see language that was sort of related to this, but had more expansive inclusion on listing things that needed to be considered as part of those circumstances in California's law. And I have a link to that in the chart. That was one of the areas that I had sort of seen a similar but different approach taken. We're then getting into Veda's fourth proposal, and this one has to do with consumer data. And the way that it's structured, and I made very little changes to this, mostly because it's really new to me, this area, and I don't understand nearly all of what is going into collecting consumer data by the dealers, what manufacturers are requiring dealers to provide, how the manufacturers are requiring that to be transmitted. So I didn't feel like I could add any clarity to the language. It was also a large block of new language. It was not amending existing language. So it's really more standalone than some of the other pieces of the Franchise Act that we've looked at, because this would be a new requirement of it. At present, the Franchise Act is silent as to what a manufacturer is prohibited from doing or what a dealer is required to do with respect to consumer data. So the first part, I see a
Senator
question.
Ingalls, sorry, Senator Ingalls, go ahead.
Just before we moved on from that, I think that we ought to hear from the dealers about that. But the dealers, several different times in conversation, have said, if you knew what the manufacturers were requesting for us to collect from the consumer and share with them, it would scare you. So we should hear from what they are asking to be collected, and let us be scared.
Okay, all right, go ahead.
So the way this is structured is subdivision A, and then it's got little Romanet 1, 2, 3, etc. says what a manufacturer is prohibited from doing. So a manufacturer needs to, it cannot, it's sort of a double negative because it's in a prohibition section, but the manufacturer cannot fail to comply with or cause the new motor vehicle dealer to fail to comply with any laws or applicable restrictions on the reuse or disclosure of the consumer data that's established by federal or state law. So it's basically saying you can't break the law and you can't make your dealers break the law. The manufacturer needs to, upon request by the new motor vehicle dealer, provide a written statement describing any established procedures that the manufacturer or a third party acting on behalf of the manufacturer has that meet or exceed any federal or state requirements to safeguard consumer data, including those established in, and it's a federal act that I would need to spend more time in to tell you what it means. That does seem to be one of the main federal pieces of law that would have a bearing on what dealers are doing with respect to data. Also a prohibition for the manufacturer to not, in response to a written request from the dealer, fail to provide a written list of the consumer data obtained from the dealer and all persons to whom any consumer data has been provided by the manufacturer or a third party acting on behalf of. This factory on the bottom of the page in line 21, the Veda's language said factory. I thought it might need to be manufacturer, and the editors also thought it might need to be a manufacturer. So that is definitely something to get confirmation on. But for the preceding 6 months to fail to provide what data had been collected and who it had been provided to, I think this gets to what Senator Ingalls was just speaking of, is here what data is being collected and who it's being provided to. The dealer can only make a request for this written itemization once every 6 months. And the list shall indicate the specific fields of consumer data that were provided to each person. Another prohibition on the manufacturer is that the manufacturer cannot require that the new motor vehicle dealer grant the manufacturer or third party access to the dealer's data management system in order to obtain consumer data, but rather the manufacturer data needs to, or third party needs to accept data in a widely accepted file format, such as comma delimited, which I don't know what that is, by the third party vendor. But the manufacturer can get access to the data management system if they have written consent to do so, and then provides what needs to be in that written consent and how it can be withdrawn. Again, something that I would probably be interested in hearing from the dealers and the manufacturers about is what sort of access is being given to these data management systems and what these data management systems have and how information can be extracted from them. Another prohibition, this one has to do with indemnification. It requires the manufacturer to indemnify the dealer if there are any claims asserted against the dealer for damages related to the dissemination of consumer data in violation of the section. Almost done with the prohibitions on the manufacturers. Final one is the manufacturer is prohibited from providing a benefit or incentive to a motor vehicle dealer if the new motor vehicle dealer is refusing to give the manufacturer access to all or parts of the data management system. So saying you can't punish the dealer for not giving access. Subsection B then goes through and lists 4 instances where the manufacturer can require that the dealer provide consumer data. And these are to satisfy safety or recall notice obligations, complete the sale and delivery of new motor vehicle dealer, validate and pay customer or new motor vehicle dealer incentives, or to submit to the factory claims for any services supplied by the new motor vehicle dealer for any claim for warranty, parts, or repair. In VEDA's proposal, they said there are similar consumer data protections in, and it listed a bunch of states. I looked a little bit at California's and Arizona's. They were the first 2 alphabetically. I also looked at Arizona because the response that you got from the Alliance said that this list of 4 instances where the manufacturer can get data from the dealer, in Arizona's law, it was a list of 10, not a list of 4. And this is the first 4 items on that list. So I would be interested to hear about items 6 through 10 and why the manufacturers think it's important that they be able to have access under those instances, and the dealers did not include it in their proposal. I also can delve more into the different consumer protection laws that are out there. It could also be that this is something that you would want to hear from the Consumer Protection Division with the Attorney General's office, or some of the attorneys in my office who spend more time with consumer protection data and privacy sort of generally and more holistically than just within the parameters of dealers and manufacturers. I know that was a lot. That was the, I think, the biggest of the densest text.
So thank you for acknowledging that was a lot, because I don't know if we're looking to move this out quickly, but I have a couple of broad concerns that I'll need to reread the language twice, and I don't think we can resolve it this morning. But I would be concerned in one of the passages you just went through if any of that could restrict or make it so that manufacturers, I too want to protect the dealers, but I also want to acknowledge that manufacturers are going to have some sophisticated supply chain systems for tracking parts and warranties that are going to create efficiencies for both the consumer as well as tracking safety. So I'd hate to have any of that language prohibit General Motors or whoever from requiring dealers to make orders and track warranty issues within that system. So I think we need to walk a balance there, and I would want to reread that language. And one of the first things you said on over-the-air updates, I'd also be concerned if we restrict and make sure that those have to go through a dealer. I think there's going to be, as these cars get smarter, we're going to need to make sure that they flexibly can get safety updates and can track as much as possible directly using our cell and wire and other data networks without having to go through a dealer. So I'm glad you said there's a lot in there. I'd love to hear from the chair and the committee as to what the timeline is for moving this forward, but I just think there's going to need to be a lot more discussion on a lot of these issues.
Okay. What is the
What is
timeline?
this?
We don't have to get that out this week, do we?
If it were to be a committee bill and you weren't to get permission from Senate rules, it would need to be voted out on Thursday.
Okay.
But do we have a bill?
Oh, would you have a bill to put it on? I think
Yeah,
it's
on the wall.
It's on your wall.
Well, we'll have the T-bill at some point. And then what I think overall, I mean, first of all, it is not done. There's other sections, but
Right.
I think a discussion with Representative Marcotte would be in order before we spend too much time, because if they're going to really dig into it, I would think that would be to our advantage to wait and see what they do, because this is mostly contract law. And if they have the time to bring in all the different parties, then we would benefit from what they learn from their discussions. If Representative Marcotte wants this committee to really work on it or not, I don't know. I haven't talked to anybody on that committee about it.
They also have a later deadline in the House for committee bills. That's March 31st of 2022.
Okay.
That's past crossover as well. We don't have crossover yet.
But yes, it would be past crossover.
So we have a crossover deadline that.
Those are questions for the parliamentarians. I think Secretary Bloomer would probably have things to say about the deadlines in the different bodies and how they align.
I know. Well, I'm raising the issue because we have had a terrible problem with crossover and so many bills coming up over from the other body very late, and the time compression has been a source of concern. And so that's why I'm just reacting to having a committee bill deadline that in fact would be later than crossover. But
I know Rules
that-
Committee always lets the bills go through. I mean, rules always, they very seldom ever deny bills. But
yeah, but Senator Maz, it's been a source of concern about, here's a bill and we've got 2 weeks to work on it and it needs to get out.
yeah. All right.
On the other hand, I do feel the expertise of the committee, the policy committee, could be very helpful, because I'm like, this is getting me into an area that I have no background or any foundational knowledge. So, I could say this sounds fine and then discover that there's a whole lot more to it or nuance that, just unless you have that understanding, can be a problem. So it's sort of like, I feel, I know the dealers are putting this forward. It's what they want. And so I'm like, well, are we just doing a bill to, that would recognize or give the Vermont dealers what they're requesting, but without that full understanding or testimony? That's why I just find this a very difficult area to venture into. Senator Chittenden wants to read it twice. I probably would have to read it about 10 times and not sure that I would still be grasping it all. So that's my concern about if we could talk to the Committee of Jurisdiction in the other body, that might be helpful to figure out how much time we want to spend on it, if in fact they're going to move a bill. But we don't know that right yet.
Senator Chittenden?
Yeah, so I didn't know how many times I'm gonna have to read it, but I'm probably gonna have to read this twice as many times as Senator Kitchell. I also just wanted to say, Senator Mazza, that I rescheduled my 11:30, seeing the depth of this bill. So I will not be leaving at 11:30. So that's an extra 30 minutes to solve this dealer manufacturer contract law thing. So whatever that's worth.
Whatever you say. Thank you. Senator Perchlik.
Yeah, well, just talking about the schedule, I didn't know if we wanted to circle back to the miscellaneous DMV bill and try to deal with that today, or
Sure. I think we should. I thought we were going to do that. So maybe we should, because this one's going to be have some discussion to it. We're not going to get this resolved this morning, that's for sure. So why don't we do unless there's objections, should we do the DMV bill?
Yeah,
Okay. Anthea, I'm sorry, can we do that?
Oh, yeah.
Okay, because we
I am
certainly.
happy to take a break from franchise law.
Okay, good, thank you. You've done a lot of research, oh my God.
Okay, so what Jeannie has posted up on the committee page is the language that you looked at yesterday where we got rid of the retroactivity piece. And that is the version that is up on the committee. You would be able to vote out now. But what I did in your break was I mailed some language to Deputy Commissioner Smith. I don't know if he's had a chance to review it. I haven't had a chance to look at my email. So if he emailed me, I did not see it. But I see his face.
He's right
So
on here, okay. Mr. Smith.
So again, Michael Smith, Deputy Commissioner of DMV, almost a Director of Operations, blast from the past. So I've looked at the language. I had a few minutes to chat with our AG. Just a couple of questions on it. So we're redefining or expanding the definition of motor vehicle in this section. I just want to make sure that doesn't impact the definition of motor vehicle in section 4. I don't think it does, but I just want to make sure of that.
It does. Oh, I can answer that one quickly. It does not. And I can put this language up on the committee's page. It just says for purposes of 2151 as used in this subchapter. So it is just subchapter, I think it's 7 on abandoned vehicles.
Okay.
So no effect to 23 VSA section 4.
So ATV, snowmobiles, and motorboats are titled under chapter 36. So do we need to have some reference to chapter 36 because the titles aren't created under the section that the abandoned vehicle section is in? And again, not being a lawyer, I'm just pointing out questions.
yeah, but what section are the automobiles titled in?
Yeah, so none of them are titled in the abandoned vehicles chapter. Would you not be able to get I think it's the salvage title for an ATV?
Boy, I think we expanded those statutes years ago, once we started titling ATVs, boats, and snowmobiles to allow for salvages. But all the other titles are under chapter 21. So do we have to say something like under this chapter and chapter 36 to encompass all of those?
So what we're saying, and I'm going to put this language up so the committee can see what it is that Deputy Commissioner Smith and I are talking about. So what I have done in this iteration is for purposes of subchapter, I think it's 7, there's a definition section, and at present, it just has a definition for abandoned motor vehicle. It does not define what motor vehicle means for purposes of the abandoned motor vehicle definition. And the definition of motor vehicle for the chapter, not the subchapter, I don't think really helps the matter. So what I did for this language, for discussion purposes only, I wish I could put it on here, go back in time, is motor vehicle means all vehicles propelled or drawn by power other than muscular power. That's the first part of the definition of motor vehicle in section 4. But then it goes on to have a bunch of exceptions. And this instead says that have or could have a registration plate or public vehicle identification number. So my questions are going to be very sort of administrative. Do ATVs and snowmobiles have a registration plate or public vehicle identification number? Because maybe what needs to change to this language is that it's titled or could be titled.
So so they all have bins.
Okay.
They all have public VINs. A ATV would be issued one of the little metal plates. A snowmobile is issued a validation decal that's stuck on the side of the tunnel. And a motorboat is issued a number that you then buy the little stickies and stick them on the side of the boat. So I don't know, so I did have questions in regards to registration plate, because I don't know as though that really encompasses those other two pieces. So I wonder if the correct way is to reference that it's been titled, but then we also have the situation of vehicles that are not titled are abandoned.
Right, but it could
Right.
be that could be titled piece.
Correct. Correct. But again, I mean, some of the vehicles that they find abandoned could have been titled, but now they're too old, so they can't be titled. And I don't know if that draws an issue. The other
So-
distinction, whoops, sorry.
Oh yeah, I'm just saying, and we're now like drafting language on the fly on YouTube for everyone to see. We could put it out, break it out as one or more of, so provided that it could be titled, or it could have a registration plate, or that it has a public identification number, so long as it's one of those three things.
Mhm.
Maybe that would cast our net as wide as it needs to be.
Do we need to add in like validation decal or something to cover snowmobiles, or do you think that's covered by they could be titled?
I think it is covered by that could have a public vehicle identification number.
Okay.
'Cause that was one of the first things you said was snowmobiles would have a VIN.
And I
But we could
wonder if
expand the registration plate to be or a decal or a boat identification number, or cover those three.
So I wonder, one of the final issues I had was in regards to UTVs, because ATVs have a specific definition and there's weight and width. Some of the UTVs that are coming out are heavier and wider, so technically they don't fall into the definition of an ATV, thus they can't be registered, but they would have a public VIN.
If they had a public VIN, I think the way we would structure this, we could capture it there.
Okay. And
What's a UTV? UTV,
and I can't remember what the U stands for, utility. type
Utility.
Yeah,
okay.
so, I mean, ATV, UTV, I would say that they're interchangeable until you get to looking at registration purposes, because they're all designed for off-road use. But at the end of the day, because the definition of an ATV is narrow, 2,800 pounds, and I think 64 inches wide, you're kind of limiting right there. If the UTV was 65 inches or 3,000 pounds, because some of these are like 4-seaters now, they're huge, so.
Deputy Commissioner Smith, I'm gonna put the language back up, but what was the correct phrasing for the snowmobile decal and the motorboat piece? Sorry, the vessel piece.
Snowmobile, let me just look right in statute to see what it talks about. So it's a registration decal for a snowmobile.
The decal, isn't it for a boat on the side?
I think
Well-
it's an identification number. I think it's phrased differently. Or maybe it's a validation sticker.
Yeah, all I can find is registration numbers. Where we assign that number to them. And then you buy the little 4-inch numbers or whatever at the hardware store and stick them on the side or paint it on, I guess. So,
Certificate of number awarded to such motorboat.
there you go.
Okay. Can you now see this language? I think I've been sharing my screen this whole time.
Yep.
Okay, so what I did was I changed this. So motor vehicle means all vehicles propelled or drawn by power other than muscular power that have or could have one or more of the following: a registration plate, registration decal, or certificate of number, public vehicle identification number, or Trying to figure out if there should be A's there. The editors can tell me if there should or shouldn't.
I was gonna say, I can't help with that. So,
Do you think that covers everything that should be abandonable?
did you
Under
just make
this?
that word up? I think it does.
As a trailer has a registration plate.
And
And-
it
I
falls
know
under-
Mike, because Mike helped me get one.
Yeah.
Get your
Mike,
initial
Mike-
on it?
And do I
Mike,
get, excuse me?
I was just gonna ask on the trailers, anything that's towed needs a separate registration, is that correct?
Except for a pole dinky, which is what you put a telephone pole on that hangs behind the truck, and a tow dolly. Other than that, everything else must be registered.
No, I think this is good. And then there's the second part about the 90 days.
Yep, that one's way more straightforward.
Yes,
Section
it is.
9, striking out 30, replacing it with 90 on line 10.
Mhm.
That one I knew what to do. So if this works for the committee, what I would like to do is just get an editor to look at it super, super quickly, and then I can get you a full version of the bill, if the intent is to still vote it out
Sure.
today.
You want to take a 10-minute break and do it then, or how do you want to do it?
I hope that 2 pages can get a quick editor look and be done in the 10
Okay,
minutes.
let's get back at 11:30. Okay?
Okay,
We'll do that?
it's 11:23 now.
Yes,
We
right.
do 11:35.
11:35. Okay, sure.
Thank
No
you.
problem. All right, 11:35. Thank you.